Welcome back, everybody, to this RECONNECT annual conference on earnings EU citizens' trust, rethinking democracy, and strengthening the rule of law. In this session, we will have our second keynote speaker of the day on setting up European Public Prosecutor's Office, a way to reconnect people to Europe. The EPPO officially started now 1 month ago on the 1st of June. We are very privileged and honored to have with the first European Chief Prosecutor, Ms. Kövesi, and she will talk about setting up EPPO. We want to organize this keynote in an interactive manner as we have done throughout the day. So if you have any questions, you can send them to us via the question box and we will feed them into the discussion. The European Public Prosecutor's Office is an independent and decentralized prosecution office of the European Union, with the competence to investigate, prosecute, and bring to judgment crimes against the EU budget, such as fraud, corruption, or serious cross-border VAT fraud. It constitutes a new crucial building block in strengthening the rule of law in the European Union. The EPPO presents a transformative response to fraud and has arisen in part due to the borders that are open to fraudsters and criminals, but close to the bodies responsible for investigation and prosecution. In her keynote, Ms. Kövesi will discuss the creation of the EPPO as a new tool for the Union to better enforce the fundamental values of democracy and rule of law. Ms. Kövesi is the former Chief Prosecutor of Romania's National Anti-Corruption Directorate, a position she held from 2013 to 2018. Prior to this, between 2006 and 2012, Ms. Kövesi was the Prosecutor General of Romania, attached to the High Court of Cassation and Justice. She was the first woman and the youngest Prosecutor General in Romania's history. In October 2019, Ms. Kövesi was confirmed by the European Parliament and the Council as the first European Chief Prosecutor to head the European Public Prosecutor Office. We are very privileged and honored that you join us today on this annual RECONNECT conference. To the audience, do not forget you can feed in questions. This is a unique opportunity to engage, and we will try to feed them into the discussion. Now it's my privilege to hand over to Ms. Kövesi.
Thank you very much for your words. I hope you can hear me and you can see me very well. Okay. Dear Professor, dear all, thank you very much for the opportunity to participate today to this debate. How can the European Public Prosecutor's Office contribute to democracy in the European Union? First, by effectively countering fear. The free movement of goods, services, capital, and people has great advantages also for criminals. Our traditional modalities of cross-border law enforcement no longer allow us to counter criminal organizations effectively. The EPPO represents a major innovation in this regard. We will demonstrate the great potential of a truly integrated European action against organized crime. However, in order to do that, we will focus only on financial and economic crime affecting the financial interest of the EU, as defined in the so-called PIF directive. The EPPO will investigate fraud involving EU funds of over 10,000 euros and cross-border VAT fraud involving damage above 10 million euros. Why will the EPPO be a game changer in the fight against fraud involving European funds? Until now, the level of protection of the financial interest of the EU was different across the member states. In some member states, thousands of investigations have taken place, while in other member states, there were 2 or even less cases per year. With the EPPO, the investigation and prosecution of these crimes will be a priority for all the European delegated prosecutors, and we will have a unitary approach. This alone should already increase the overall level of protection for European funds. The second expected improvement is in the efficiency of investigations. The EPPO will be independent from national governments, the Commission, and other European institutions, bodies, and agencies. This is very important because the independence of the institution and the independence of prosecutors is the first premise for obtaining efficient results when fighting corruption and other serious crimes. I will come back in a few minutes on this issue of the independence. A third reason for an increased level of protection of the financial interest of the EU, it's linked to the main characteristic of the type of criminality that the EPPO will tackle, the speed with which criminals react to law enforcement actions. The EPPO has unprecedented possibilities in this respect. Obtaining and aggregating information at European level, conducting investigations without being limited by national borders, harmonizing the use of the most efficient investigative tactics, using evidence collected in another member state without the need for excessive formalities, and conducting investigations simultaneously in several member states. The second main contribution of the EPPO to democracy in the EU is to be a very powerful incarnation of its fundamental values. The EPPO is the result of a transfer of sovereignty from the participating member states in a very sensitive policy area, justice. However, this transfer does not mean that the member states are not involved any longer. Beyond our central office situated next to the European Court of Justice in Luxembourg, the EPPO is also an institutional reality in 22 participating member states. There is nothing comparable in the EU architecture. We are an EU institution embedded in the national judiciaries. The EPPO is very close to the people. The European Delegated Prosecutors will investigate and prosecute according to national criminal laws, national procedural criminal laws. They will bring their cases to judgment before national courts. The EPPO will directly affect the life of the people involved in the investigations. The act of prosecution, as that of rendering justice, materializes the values of justice. This is why we can say that the EPPO is an incarnation of the Europe of justice. Prosecutors are visible because justice has to be seen. We will bring criminals to court. We will speak on behalf of the European public interest. The EPPO will be perceived as a real social actor. Connecting the Union with its citizens is for the EPPO a matter of merely doing its job. Prosecutors are here to act in the interest of justice, not to adopt and communicate about rules or about sophisticated mechanisms of cooperation between the member states. What do we need to be able to achieve this? We have to put in place the right structures and tools to perform the tasks conferred to the EPPO. This shall be done in full respect of the principles established by the treaty and by the regulation. For instance, the participation of prosecutors designated by the member states in the college does not aim at giving the member states a way to express national interest. The EPPO College is supposed to act on behalf of a superior interest, the interest of European justice. We also have to make the right choices to make the EPPO work in an efficient and independent manner. Let us have a look, for instance, at some of key questions that need to be answered before assessing whether the EPPO is capable of fulfilling its potential. Can we agree that the European Delegated Prosecutors should work full-time for the EPPO? Can we agree how many prosecutors there should be in each of the member states in order to do the job properly? What type of support and equipment will they receive? What will the overall budget of the EPPO be? Will the EPPO Central Office be able to analyze all the available information in order to genuinely improve cross-border investigations? Will the EPPO Central Office be able to improve the identification of criminal assets, thus helping the member states improve the recovery of damages? On all those issues, we try to give the right answers. We have negotiated with the budgetary authority and with the member states. We will see very soon whether some elements are missing or not. Ladies and gentlemen, I already said that the expected improvement in the protection of the EU budget is linked to the principle of independence, as Article 6 of the EPPO regulation states that EPPO shall be independent and act in the interest of the Union as a whole. This provision also stipulates that the EPPO shall refrain for seeking of taking instructions from any person or outside entity. It obliges member states and EU entities to respect the EPPO's independence. Independence is a crucial, basic rule for the functioning of the EPPO. This should be the model followed by all the national public prosecutors' offices. It is an essential guarantee against the abuse of power, which is not only in the prosecutor's own interest, but also in the broader interest of society and in the interest of the rule of law. Furthermore, the regulation lays down specific rules to make this independence effective in line with the case law of the European Court of Human Rights, reiterated by the Venice Commission. These rules relate inter alia to the appointment of the European prosecutors, the duration of their terms, and the existence of guarantees against external pressure, including decision-making on budgetary matters. Let us have a look at these three elements. The EPPO regulation provides for the selection and appointment procedure of European Chief Prosecutor and the European prosecutors, combining an independent selection panel constituted of peers and different EU institutions. Similarly, their new non-renewable terms and the fact that the decision on their dismissal is entrusted to the European Court of Justice will act as safeguards of their independence. The European delegated prosecutors are potentially more exposed to external pressure than the European prosecutors, and they have to directly carry out the EPPO's proceedings in their respective member states. Their selection is assigned to the member states, but their appointment is a matter for the College of the EPPO. The College may reject candidates who would not fulfill legal requirements with regard to their competence and independence. European delegated prosecutors are recruited for a renewable term of 5 years. This means that they have a choice. They can choose to stay in a European prosecutorial career or return to their national system. Furthermore, the regulation allows for the possibility for European delegated prosecutors to also exercise function as national prosecutors. This is what we call double-hatted European delegated prosecutors. You might have noticed that we had a frank exchange of view on this with several member states, and that the College of the EPPO put in place mechanisms to safeguard the European delegated prosecutors as much as possible. Independence is not just a word or a principle. The independence of the EPPO is also linked to the allocation of sufficient financial resources in order to allow it to fulfill its mandate, as well as to the existence of genuine budgetary autonomy to manage these resources. Maybe you noticed that we continue to have an intense discussion on this, in particular with the European Commission. However, adequate financing of the EPPO lies both with the EU through the general budget of the Union and with each participating member state, as they are obliged to provide the European delegated prosecutors with the resources and the equipment needed to carry out their duties. The decisions of the budgetary authority are difficult as they have to be based on forecasts. They should be based on objective data, but these are not necessarily always present at the moment of the decision. They also depend on political objectives, and here the key element is transparency and consistency. The budgetary authority must consistently adapt the means to the declared objectives. Only the final outcome of the budgetary procedure makes clear whether the budgetary authority actually wants to have an independent prosecutorial office. Ladies and gentlemen, let me conclude on a more personal note. In a recent decision on a case I brought against the government of Romania, the European Court of Human Rights upheld that the executive branch cannot remove chief prosecutors without independent judicial review. The court's decision stated that, in particular, that the independence of prosecutors is a key element for the maintenance of the judicial independence. I hope that this decision will give all the magistrates in the EU confidence and courage. I have been a prosecutor for a half of my life. I have combated high-level corruption for many years and have experience with the vital importance of fairness, the willingness to comply with commonly agreed rules, the ability to administer justice, in other words, the rule of law. I am convinced that with the EPPO, the Union is better equipped to enforce its fundamental values. This is the core of the European Union for me and, I am sure, for millions of European citizens who grew up under dictatorial regimes in a divided Europe. The only effective way to ensure true democracy in a globalized world. Thank you very much for your attention, and if you have questions, I will glad answer to them.
Thank you very much for your opening keynote and bringing in the different elements, also stressing the very important aspect of independence, which of course goes to the heart of the rule of law. We are getting in some questions, and if you allow me, I will feed them in. They might jump a bit from one topic to the other as they come in, but maybe let me start off with a more general question, and that is what's coming in is, why do we need the European Public Prosecutor's Office? And what is a bit the division of labor with some of the institutions which we already have, like OLAF, the European Anti-Fraud Office, Eurojust, and Europol? So where do you fit in that broader architecture?
Thank you very much. I have to explain a little bit the difference between OLAF, Europol, Eurojust, and EPPO, and I think in this way my answer will, you will have the answer to this question. For the first time, we have at the European level a prosecutor public office. This means that we can investigate, we can prosecute those who commit financial fraud. This is the main difference between EPPO and all the other bodies and agencies as OLAF, Europol, and Eurojust. No one else can do these criminal investigations, only EPPO. OLAF can have disciplinary investigations, administrative investigations, and based on those investigations, especially administrative one, they can make a report, and that report can be a base for a prosecutor to open an investigation or to start an investigation. Europol and Eurojust are agencies of EU that are their main jurisdiction is to improve the cooperation between the member states, between the law enforcement agencies. So they cannot investigate, they cannot prosecute, they cannot plead in the court, they cannot seize assets, they cannot take preventive measures in these cases. Only EPPO can do that. So this is the role of EPPO, and for the first time we have a prosecutor office at the European level. This means that we can investigate efficiently financial frauds, we can detect better and investigate better cross-border crimes and all those crimes that are committed in different member states or in a member states or third countries.
Thank you very much. You officially started up on the 1st of June last month after a preparatory period. One of the people from the audience asks, when will the EPPO start investigating crimes? When can we expect to see the first case brought by the EPPO to courts?
So the first investigation started after 1st of June. We have received already the backlog of cases from the member states. And I have to describe for those who are not exactly working in the judiciary that we have two different situations after 1st of June. First situation, after 1st of June, we started to receive the ongoing cases, ongoing investigations that were at the national level. In these cases, EPPO has the right to evocate the investigations. This means that we analyze the facts, we analyze the crimes that are investigated, and we can decide that we will take over the investigation and we will continue the investigation, or we cannot evocate the case and to send back those cases to the member states. We will take this decision based on the objective criteria that we have adopted in the college, and this means that we will take only the serious cases, cross-border cases, because EPPO was not created to investigate petty cases, and the role of EPPO is to protect better the EU funds. This is the first situation, and this is applicable to all the crimes that were committed before 1st of June. For all those crimes that are committed after 1st of June, and falls under the EPPO jurisdiction, for those cases, we have a mandatory competence. This means that in all those cases, EPPO will make the investigation. And we already started to do that, and we already have investigations, and we started to investigate cases. But for me, it's very difficult to say in this moment when we will have the first, for example, the first indictment. But it's clear that we have investigations in 22 member states, and as soon as possible, this or a part of this investigation can be finalized with the indictment. I think we will do that. Maybe the questions is related to the credible results that EPPO can have, and I have to say that the credible results means to have also judgment in front of the court. You are credible when your indictments are judged in front of the courts and you have decisions in the court. And I don't think we can have final decisions in the court in 1 year, but let's see.
Okay, thank you very much. We are getting a question on, let's say, the scope and competence of the EPPO in relation to the following question. Are money laundering and or unlawful assets from corruption held in the EU but coming from third countries also going to be tried by the European Chief Prosecutor?
So based on the regulation, we have also competence to investigate money laundering, corruption, organized crime, if these crimes are related to the main competence of the PPO, for example, fraud with EU funds. In these cases, we can have the investigations. Also, we can investigate the crimes committed in the third countries if there are connections with participating member states in the EPPO. For example, I can give you an example. If we have a financial fraud that falls under the EPPO jurisdiction committed in, let's say, Romania and Germany, and a bribe that it's related to these crimes, or money laundering that it's related to these two crimes committed in a third country like Ukraine or Moldova Republic, in this case, we have jurisdiction and we can investigate.
Okay, thank you. One question relates to the structure you outlined, which is this, let's say, multi-level structure where you will have the delegated prosecutors, member states pursuing cases to their national systems. There comes a question in on the differences between civil law and common law countries, and whether it's feasible to imagine the adherence of a common law country like Ireland to the EPPO.
I'm not sure that I got the question. If it's related to the structure of the EPPO, or
whether the system of the European delegated prosecutor fits within the common law countries approach like Ireland.
Yeah. Well, in my view, it is possible this shouldn't be the fact that there is a common law civil law shouldn't be an impediment. That we already have an example in EPPO. It's about Malta. They don't have the civil law system; they have the common law system. So it's obvious that they can be part and they can't fit in the EPPO system. But of course, I have to underline a little bit that it's in a way it's really challenging to work with 22 different criminal codes and 22 different criminal procedure codes. But until now, we dealt with that, and until now, I can say that yes, we can work.
Okay, thank you very much. We're getting also questions in, partially also following, I think, the taking over of the presidency by Slovenia of the European Union, with regard to let's say the appointment of the Slovenian European delegated prosecutor. And the question which comes from one of our colleagues is, how can you guarantee national governments do not corrupt national selection processes for the European delegated prosecutors? We have, for instance, seen an attempt in Slovenia, and we were wondering if you could comment on that.
Well, about Slovenia, maybe you already saw my previous statement, but I have to say that in my view, it's a lack of sincere cooperation, because they decided to be part of the EPPO. So one of the obligations that they have is to propose the appointment of the European delegated prosecutor. That this is something that it doesn't happen until now. We cannot influence the government decisions, and I don't think EPPO should do that. Based on the regulation, the national authorities should propose the candidates, and the college of the EPPO, based on the proposal of the European Chief Prosecutor, can appoint those candidates or can reject those candidates. And this is something that we already started to do it, because we have an internal procedure, we develop internal criteria, and in some situations, for example, we already rejected the candidates if they didn't fulfill the criteria. And we have some criteria. One is the experience in investigating this type of crimes, and another criteria is related to the independence. So we have to be sure, and in all my requests to the member states, after we reach an agreement related to the number of the European prosecutors, delegated prosecutors, I have asked to have transparent and very public procedure to recruit the candidates that will be proposed to the EPPO, because in my view this is very important, and the European delegated prosecutors are the core of the EPPO. They should be independent, they should be professional, they should be active, they should be courageous. And it's very important to have only independent prosecutors. We cannot influence the decision of the government, but it's very important to say that we can reject the candidates if we have doubts about the procedure, or if we have information or evidence that the candidates were not selected based on their professional background.
Thank you very much. If I may, can I have a follow-up question on that? Can you maybe elaborate a little bit more about what these, let's say, transparency requirements are for the procedure? When do you consider these procedures to be sufficiently transparent?
In general, in all the member states, the procedure to recruit the European delegated prosecutors was public. The interview were public. It was a public call. There were a lot of candidates. The national authorities organized an interview with the candidates. They assessed their theoretical knowledge, their experience. So for example, if I have to give a negative example, it didn't happen, and I hope we will not have this situation when the member states pick two candidates without any kind of selection procedure, without any kind of procedure. No, that is not transparent.
Okay, thank you very much. There are also questions coming into this, let's say, in relation to the fact that some member states have not yet joined the EPPO. And one is, of course, do you see them joining in the near future? How do you see the non-members joining in the near future? But there is also another question related to Hungary, which is one of the states that has not joined, but has signed a cooperation agreement with the EPPO. And what does this mean for a non-member country to sign a cooperation agreement? So there are two sets of questions. One is maybe there are some member states who are not yet have a cooperation agreement and you see them joining in the near future. But for some non-members, they have signed a cooperation agreement. And what does this specifically imply?
Mm-hmm. Well, the decision to join EPPO is obviously political one, so I cannot comment on this, but I hope our activity will convince them that it is better to join, and at least as prosecutors, we would like to work with all our colleagues in Europe in the same way. But we have started already to have discussions with the colleagues from non-participating member states and to negotiate to sign some working arrangements. For example, with Hungary, we already signed this working arrangement. And this means that we establish a channel of communication, we establish how we will exchange the information, the good practices, and how we will cooperate in our cases. So also we will start to have this working arrangement also with the third countries. And in general, with non-participating member states, with third countries, we will use the same tools that we had until now related to the international cooperation. And also we have working arrangement with Europol and Eurojust, and they will be our main partners when we speak to cooperation with non-participating member states or with the third countries. We will work together on that.
Okay. Thank you very much. We have a question coming in which relates actually quite close to the core of our RECONNECT project, which links rule of law, democracy, and human rights protection within the EU. And the person asks, there are several crimes committed against, for instance, political rights of citizens, including the right to elect members of the European EU Parliament in fair elections. And that's sometimes inhibited by corrupt governments who spend money to try to, let's say, pursue their own interest against those of the EU. Are these types of cases you can investigate and prosecute?
Well, the competence of EPPO is clear. If there is a crime that involves the frauds with EU funds, we can investigate. If we have a crime, I don't know, VAT with the damage more than 10 million euros, we can investigate. Corruption related to frauds with EU money, we can investigate. So these are the crimes that we can investigate. In the situation, it's very difficult for me to comment on hypothetical situations, but in these hypothetical situations, if there is any kind of crime with EU funds, yes, EPPO can investigate, and we will do that.
Okay, thank you very much. That's again, I think a question related to the point you already made on independence, but how will EU citizens be sure that the EPPO is not captured at national level by political processes and political opponents, and to really safeguard the independence and the mechanisms which are there as safeguards for independence?
Yes, I said few words at the beginning, but I can add something more. And another guarantee of independence is also the way how EPPO was designed to work and how EPPO was organized. For example, we have this system with the permanent chamber. What this means? So we have here in Luxembourg at European at central level, one European prosecutor for each member states. And we have to organize permanent chambers. In this moment, we have 15 permanent chambers. We have 3 different prosecutors from 3 different member states in one permanent chambers. For example, I'm in a permanent chamber with a colleague from Czech Republic and a colleague from Latvia. And we have to supervise investigations that are in Bulgaria, in France, in Germany, in Estonia. This is a very good system because no one can fear in the activity of the European delegated prosecutors. No one can give them instructions. Only the permanent chamber can do that. And in the permanent chamber, we have 3 prosecutors from 3 different member states. Also, the main decisions in the case will be supervised and will be decided in the same permanent chambers. And it's very difficult to imagine that, for example, someone from the national authority or a national politician will dare to interfere in the decision of the permanent chamber. But as I said in my previous position, I will say again, if someone will try to interfere in the activity of the European delegated prosecutors or in the activity of the permanent chambers of European prosecutors, we will make public these attempts.
Thank you very much. I've got a, let's say, more general question in related to you just started up, and all this is really very much, let's say, work in progress, and you're building this up. But what do you foresee or envisage as the, let's say, most important challenges in the near future in let's say, making the EPPO operational and effective?
The main challenge was to start the EPPO, and as you already saw, we had a problem because we could start without one member state, without having European delegated in one member state, but it's almost impossible to be efficient without having European delegated prosecutors in all the member states. So this was the first challenge. Now, another challenge is to try to have a unitary jurisprudence. In the conditions that when we have to apply 22 different laws, we have 22 different judiciaries, but we have to act as a unique office, as a single office, and to have a very constant and consequent jurisprudence. But in my view, the most challenge, the biggest challenge of the EPPO, it is to win the trust of the citizens. And we can do that only if we work efficiently, only if you work, as I said, by the book, respecting all the time the laws, the treaties, the regulation, and the fundamental rights of the people involved in the procedure. And I think only in this way we can win the trust of the people. And for a prosecutor office, I think this is the main challenge.
And are there, let's say, special ways in which you can engage with citizens or try to build that trust? You, of course, will build that trust through the actions and you take, but are there other ways you can try to, let's say, make the EPPO more known and also build that trust via different mechanisms?
Well, the best PR, let's say, is to have a good and quality activity. But of course, we have to be transparent in our activity in some limits. And the main relationship with the citizen can be that one in which they can send us information, complaints. So we have on our website the possibility for the citizens to send complaints directly to the EPPO. And we have this form in the languages of all the 22 member states. So, for example, if someone from Bulgaria, someone from Malta, someone from Cyprus wants to send a complaint to EPPO, they can do that via our website. And I think in this way we can receive all the information and all the complaints that the citizens wants to transmit to the EPPO.
And are you aware of, especially then in member states, that special actions are taking to inform the citizens of this possibility? Because potentially it's a very strong mechanism and also providing access to EPPO. Are there any actions taken to inform citizens and NGOs or other groups about these opportunities?
Yeah. First of all, we tried to do ourselves using our European delegated prosecutors and the European prosecutors. There are some member states where they started to explain and to have campaign to inform the public about the EPPO. We are in touch with some NGOs. We participate to a lot of conference, seminars, trainings in the university, and we are trying to explain to the students, to the public, what is EPPO, what are our jurisdiction, what we can do, what we cannot do. So now we are at the beginning. It's a long way in front of us, but we started to do that, and I hope in few years all the citizens in Europe will be more aware about what EPPO is doing.
Follow-up question on that, which is coming in, and but maybe already looking a bit into the future. But if you would now look 5 years from now, when would you, let's say, satisfied? When do you think you have had a successful start of the EPPO?
Well,
On what type of performance measures should that be assessed?
well, I have a mandate of 7 years, so already 1 year and something it's gone. Well, I think the success, it's the first success is that we succeeded to start. But I think we can say that we had the success only when we have the trust of the citizen. And in the moment when we will hear the citizen saying, I have this case, I will go to EPPO, only them can solve this issue. In that moment, you can say that you have success. It's very difficult because a prosecutor office, it's a living institution. And you cannot count the success in the number of cases. What this means, if you have 1,000 person who were convicted in 1 year, you can say that you have success. You cannot say that. But when the people trust in this institution, when the people have trust to come to send complaint, and they see that the law is equal for everybody, and you investigate in the same way all the people, even if they have a higher position in society, even if they are rich, and you treat all of them in a equal way, I can say yes, you are a successful institution. If EPPO can prove that the law is equal for everybody, in that moment, I will say, yes, EPPO has success.
In that way, it certainly has a crucial component on, let's say, protecting rule of law and making some of the fundamental values of the EU really being implemented. We get a question in on the relationship between EPPO and, let's say, national authorities. And the question is, what makes the EPPO better equipped than national authorities to fight corruption?
It's not, it's not necessarily that we are better equipped, because in this moment we have some problems with the budget. What maybe it's better to explain what EPPO can bring as an added values, and what the national prosecutors cannot do, and EPPO can do it. Because if we compare the budget, it's obvious for me that the National Prosecutor's Office has more budget and better budget that the EPPO has now. But the added value of the EPPO is, first of all, that we have a unitary approach in all the member states. And as I said at the beginning, there are huge discrepancies between the member states. And based on the statistics that I have seen in the last 4 years for all the member states, I saw that in some member states, the level of detection, the number of investigations were so low that you can have the impression that those are clean country, but there are not clean country. And it's obvious that it was not any kind of interest, and it was not a priority to detect and to investigate this type of criminality. Second, when we speak about cross-border investigation, we have a unique system of case management system. So all the cases are registered in this case management system, and we have access to all the cases in the same time in 22 different member states. This means that here in Luxembourg at central level, we have a pool of case analysts, and we can analyze all the information, we can connect the dot, and we can identify the cross-border criminality better than the member states can do. Another added value of the EPPO is the fact how we will work. For example, especially when we speak about cross-border investigations. And I will give you an example of the case that we already have registered, is a VAT carousel fraud, and the crime were committed in the 6 different member states. The damage estimated it's around 70 million euros. And in this type of case, the advantage of EPPO is that we can communicate directly. All the ADPs, for example, an ADP, European Delegated Prosecutor from Germany, can call his colleagues from Italy, from Romania, from Netherlands. He can ask for documents, for evidence, and those evidence can be used directly in the investigation. This means that Now, a European delegated prosecutor doesn't have to follow heavily formalities that were used before having EPPO, and he can receive all the evidence in the short period of time and faster than it was before now. So these are the advantages of the EPPO, and I think that in this way we will increase the efficiency in this investigation. And it's very important to say that one of our priority, it's not also to investigate, it's also to recover the damages. And what happens until now, it was the fact that all the time this recovery of damages was related to the national system. But the criminals are not national anymore. So they can take the bribe in Romania and they can have banking accounts in Spain or in Cyprus. And now having a PPO, it's easier to follow the money, to identify the seeds and goods and properties that can be seized, to identify and to follow the banking accounts. And in this way, we can increase the level of the recovering of damages.
Okay, thank you very much. We already touched upon the, let's say, relationship with some of the other institutions like OLAF and so on. But there's a question coming in related to audit authorities, both at the national level as well as the European Court of Auditors, because they are one, let's say, category of actors also checking whether there have been any irregularities in the use of EU funds. And then the question is, what will be EPPO's relationship with the audit authorities?
Well, we are trying now to establish contacts and to establish a way to work with all the institutions, not only at the European level, but also the national level. For example, with Court of Auditors, now we are in a position to finalize a working arrangement and to establish the way of communication and how we will exchange the information. Also, we have signed a working arrangement with the European Commission, because also European Commission have some duties related to in this mechanism of control of the using of the European money. We started to have a working arrangement also with the national authorities. For example, we have signed a working arrangement with the Anti-Mafia Prosecutor Office in Italy. We signed a few working arrangements with the General Prosecutor Offices, but we will have also working arrangement with the National Police, Tax Administration, in general, with any institution that can cooperate with the EPPO. It's important to say that if we want to have efficiency in our work, we cannot work alone, and we shouldn't work alone. And we should work together with all the other institutions. But because when we speak about the criminality, corruption, money laundering, financial fraud, it's not important only to investigate. It's also important to prevent. And you can do that only working together with the others. So our strategy is to develop a good relationship with all the institutions, agencies, bodies at EU level, but also in the national, with the national authorities.
Okay, thank you. Your office was set up, of course, in a very specific circumstance with the COVID pandemic, and this was unprecedented. But of course, one of the consequences also of the COVID pandemic was the important economic impact, and that has led on the level of the European Union to set up the next generation EU, the big recovery plan of the EU, and that will of course involve lots of funding, investments, projects, and so on. Is there any, let's say, role of the EPPO in, let's say, safeguarding the good use of the recovery funding?
Yes, it is, and I think EPPO will have an important role, because we have to investigate all the frauds that will appear. And I'm sure that more money, more flexibility, less transparency means more risk to have more crimes. Of course, I'm sure that the number of the cases that EPPO will investigate will be higher than it was until now, because also of this recovery plan. I'm sure that the investigations related to the healthcare system, public procurement, infrastructures will be higher than there were before, also because of this recovery plan.
Okay. Then there's another question related to, let's say, development, and I hope I understand it well. but it's related to the new conditionality mechanism regulation of the European Commission, and how you will see that, let's say, influencing your work, and whether it will facilitate some of your work in certain member.
Well, EPPO appears in that mechanism because everyone who is a part of the EPPO should cooperate in a loyal manner with the EPPO. For this mechanism, I cannot say that we have direct duties, direct competencies. We can, if we identify in our work problems that can be related to the rule of law, we will communicate this to the European Commission. I already started to do that, speaking about the Slovenian issue. The fact that they are part of EPPO and they doesn't want to fulfill their obligation, this means that we already have a big issue, because we have a gap in EPPO zone when we speak about the investigations. We cannot take all the investigations in Slovenia without having European Delegated Prosecutor, and this is obvious a huge problem. And we already started to send this to the other European institutions. So this is an example how we can be part and how we can contribute to this new mechanism for rule of law.
Thank you very much. There's a, let's say, follow-up or clarification question on a topic we discussed before, and that has to do with, let's say, the non-participating member states, but which are in some kind of an agreement with EPPO. And the question is, can EPPO bring a case before a Polish or Hungarian court currently?
We can investigate this type of crimes only if there is a link with the participating member states. For example, if a Hungarian or a Polish citizen commits a crime in a participating member state with EU funds, yes, we can investigate those two citizens, but only if we have connection between a non-participating member state and a participating member state, a company, a person, things like that.
Okay. Thank you very much for this very interesting keynote and also engagement with the audience. We know you are on a tight schedule, so we want to make sure we end on time. I would like to thank you very much for your time. It's very busy times for you, we know, but you took, let's say, the time and also the engagement to reconnect, which is close, I think, to some of the things you want to achieve, and they are very similar to some of the objectives we want to achieve in the project. And that's really trying to understand and also make recommendations on how to strengthen the rule of law. I think you're making great progress in that way. You're also, as you explained, setting that open to citizens to be able to engage with you. And I think that for the future holds a lot of potential. And I would like to thank you on behalf of our all RECONNECT consortium for joining us today and giving your insights and also engaging with the public.
Thank you very much for your invitation and for your questions. And I hope that with our activity, we can together protect better EU money, EU citizens, and in the end, Europe, because we are Europeans and we have to care about Europe. So thank you very much again.
Thank you very much. And thank you very much for the last words, which are very encouraging. So thank you.
Bye.
And now we will hand over, go directly to the next session of our RECONNECT annual conference. And it's my great pleasure to hand over to my colleague, Maaike de Ridder, who will moderate the next panel on rule of law. Maaike, the floor is yours.
Thank you, Axel. Thank you for the very interesting keynote and discussion afterwards. Hello, everyone. Welcome to the very last part of our RECONNECT conference today. Thank you so much for joining us for what is set up to be a highly interesting panel with RECONNECT's most distinguished rule of law experts. Before introducing you to them, I will quickly introduce myself and the topic of this panel. So my name is Maaike. I am one of the RECONNECT members from the KU Leuven team, and I will be moderating this panel on nothing less than strengthening the rule of law. Rule of law backsliding sadly remains one of the biggest issues for the EU to tackle, And there have been many recent developments, but luckily for us, this gives us a lot of issues to discuss. And that is exactly what we plan to do for the next hour. To build up our discussions, we will build on questions from the audience. So please feel free to send in your questions at any time through the Q&A box. And now to discuss these matters with you and to answer your questions, we are very glad to have with us Professor Laurent Pech, who is a professor of European law at Middlesex University in London and has extensive expertise on the rule of law in the European legal space. We are also happy to welcome Dr. Joelle Grogan to the panel, who is a senior lecturer in law at Middlesex University and, of course, the convener of the highly interesting Power and the COVID-19 Pandemic Symposium on Verfassungsblog, which is a mouthful. Then we are also joined by Dr. Petra Baert, Associate Professor at ELTE School of Law and visiting professor at the Central European University, here to share with us her broad knowledge on the rule of law in the EU and Hungary. We extend our warm welcome to Professor Dimitri Kotchenov, who is head of the Rule of Law Research Group at CEU Democracy Institute and a longtime rule of law powerhouse. And last but not least, we are also joined by Professor Tomek Koncevic, Professor of European and Comparative Law at the University of Gdansk, and a renowned expert on all constitutional law matters. So welcome to all of you. While we wait for questions of the audience to come in, let's start with some introductory questions based on your expertise and RECONNECT research findings. I would like to start this panel off strong by immediately delving into some questions on recent and striking developments regarding the rule of law in the EU. So Petra, the first question is for you. The Hungarian parliament recently passed a new bill banning the portrayal of homosexuality and transgenderism in content intended for minors. This bill was rightfully perceived to be an attack against the entire LGBTQ+ community and their human rights. Do you think this bill will mark a turning point for EU action against Hungary's backsliding practices? And what do you think would be the right way forward for the EU to deal with this development?
Thank you so much for this excellent question. I think it's absolutely crucial, and I'm very happy to introduce a new topic to our discussion. We have already talked about democracy, and in this panel, we will talk a lot about the rule of law, I assume. But I'm very happy to bring in a new theme, which is fundamental rights, and not only because they are enshrined in Article 2 of the Treaty on the European Union as the basic foundational values of what the European Union is founded on and what the member states agreed upon, but also because of their interconnected nature. So the rule of law without democracy is a contradiction, while democracy without the rule of law may turn into a dictatorship of the majority, which has already been said this morning. And the same goes for fundamental rights. So take, for example, judicial independence, which has been extensively discussed, which is a rule of law issue. The other side of the coin is, of course, a fundamental rights issue. From the individual perspective, the right to a fair trial. Now, being a rule of law violator is a great stigma these days. So every step to deconstruct the rule of law has a veneer of legality. And we can say the same thing also for fundamental rights violations. So the human rights paradigm became so powerful these days, and especially since the Second World War and the Shoah, that no government in the world would today openly challenge it. So any attempt to do harm to human rights is disguised. I'm sure my dear colleague Joelle will talk a lot about emergency situations where allegedly there is different balance between the right to liberty and security, or proportionality considerations have to be allocated differently than in normal times. But there is also another type of an attack against fundamental rights, a disguised one, where the attack comes or is repackaged in the form of alleged clash of rights. And this is exactly what happened in the Hungarian case. Seemingly on paper, this is a piece of law to protect children's rights, but in the end of the day, this is a very homophobic law. Now, of course, it's being a human rights violator, it goes hand in hand with being irrational. So today, Teachers couldn't teach Oscar Wilde or Emily Dickinson or Sappho's poems in Hungarian schools, but this is also a direct attack against children's rights. For example, take two teenagers who have a relationship and who are of the same sex, and they are being bullied or harassed. The teacher or the headmaster cannot discuss the situation in school because the law doesn't allow it. So this is an open invitation to bullying and to harassing children. Now, you may say that human rights violations happen all over the world, which is of course true, but there are, I think, at least three characteristics that make the Hungarian case distinct. There is a quantitative and qualitative difference in attacking all sorts of minorities. The traditional unpopular minorities, suspects, convicts, the LGBTI community, Roma, the Jews, but also there are new minorities, anyone who is different from the ordinary, like, for example, women who want to give birth in their homes. There was a war waged against them. The second difference is that all these cases are red herrings to divert attention from other deep rule of law violations. Now, there is the Fudan University and very dubious deals concluded with them. There is a concession agreement for building highways for 35 years, preventing any type of competition. And now everyone is talking about this law. Of course, there are red herrings which are not detrimental to fundamental rights. They are not taken seriously, like toying with the idea of reintroducing the death penalty. No one was harmed, nothing happened, the idea was dropped. And there are red herrings which are very much against human rights and decency and humanity in general. And there is a third characteristic, and I will stop here, is that captured institutions in these states, they rubber stamp human rights violations. Take, for example, the criminalization of homelessness, which was rubber stamped by the Constitutional Court, or take, for example, the regulation of life imprisonment without the possibility of parole, which was clearly against the Strasbourg case law for a long time. However, the Constitutional Court refused to go into the merits and thereby please the government. So I assume that these cases make the Hungarian case very unique, and there should be a coordinated response on the side of European institutions. Now, even if there is one and there are judgments rendered, the gist of the matter is the enforcement of the judgments, and the enforcement is often faulty, incomplete, or non-existent. So this is how state capture and systemic human rights violation happen in broad daylight in the heart of Europe, and this is how they become normalized by the lack of efficient European responses. Thank you, I stop here.
Thank you, Petra. That was very insightful already. I hope we can come back to some of these issues later on in the panel. I heard you say something about rule of law attacks, that they can be disguised or that they can be done while diverting the attention. And I think that this is also something that Joël has experience with, because this is also something that happened during the COVID-19 pandemic, that rule of law attacks happened whilst being disguised as emergency measures. So Joël, you have conducted extensive research on this. And could you maybe explain the impact that COVID-19, for example, has had on the state of the rule of law in the EU, and whether it has highlighted these particular vulnerabilities within the Union and its ability to uphold the value of the rule of law?
What a question. First off, I am delighted and privileged to be joining such an estate of powerhouses on the rule of law. So just by way of brief background to the research that will contextualize everything that I'm going to say today, over the course of the last year, I've been looking at the impact of the pandemic in about 70 countries worldwide, including the EU 27. There are some truths that are emerging, not only EU issues, but global issues. The first and foremost among them is that it has exposed the vulnerabilities in our legal systems. It's exposed the vulnerabilities in our capacity to respond to emergency. But it has also deepened endemic socioeconomic inequalities. Very, very simply, the most vulnerable in our communities, in our society, of our citizens, are the most negatively and disproportionately affected by not only the virus, the disease, and also by the measures that are being adopted in response to them. Now, in terms of picking up so much on what Petra has just said, we've certainly seen critical rule of law issues that are, again, being transversal issues exposed across the EU. And I can condense them into three. First, the issues of legality, second, legal certainty, and third, accountability to the law. Very simply, we're seeing governments using legal bases that don't exist. They're using law in a way that it was not intended, or they're even not using law at all to apply measures that simply shouldn't exist whatsoever. Second, in terms of legal certainty, I doubt there's a single person out there listening right now that has not wondered at some point over the last year whether or not a measure actually applies to them or how they should properly understand a measure. I know in the context of here in the UK, myself and Laurent have certainly been suffering that a lot over the last couple of months. Third, and this is a critical issue, again, pushing so much to what Petra has just said, it's accountability to the law. We're seeing parliaments deferring a lot to governments or simply not being engaged or asked to be engaged with these measures. That's a critical issue, not only in terms of democratic legitimacy, but also, well, the rule of law. Now, one final point that I do need to emphasize is these are transversal issues. This is not just one state. This is not North Europe, South Europe, East Europe, or West Europe. This is across Europe, across the EU, and tragically across the world.
Thank you very much, Joël, for your answer. I would shortly like to remind the audience that you can ask your questions at any time for any of our panelists, and I will do my best to weave them into the discussion. So please feel free to use the Q&A box. Now Joël and Petra have given great examples of some practical challenges to the rule of law, but of course RECONNECT has also focused on a more conceptual challenge that the rule of law may face, and I will address this question to Laurent. So Laurent, some EU member states have already contended that the rule of law has no core meaning, and that this lack of proper definition is actually the reason that the EU is disabled from enforcing the rule of law in the member states. Could you please share with us your findings on whether these member states actually have a point?
Yes, thank you very much. Just to get started, let me note in passing, it's quite strange that those arguing that the rule of law cannot be defined in EU law or even in national law are the ones who tend to actually violate the rule of law, just to note in passing. But leaving this aside, so yes, you are, I think, referring to the pending annulment action initiated by the Hungarian and the Polish governments before the Court of Justice. One of the annulment grounds they're raising to convince the Court of Justice that the EU rule of law conditionality regulation is not compatible with the EU treaties is that there is no such thing as a rule of law. It does not exist in EU law. And it cannot even be defined in EU law, even if it did exist. Now, this is obviously not a serious argument. Our research, I would refer the audience to our first two RECONNECT deliverables, which can be found on the website. We use some technical coding, D71 and D72 for deliverable 7 number 1. And deliverable 7 number 2. So essentially, we tackle with this kind of issue about the core meaning of the rule of law. Is there more unity than diversity across national legal systems? And essentially, our core answer is there is such a thing as the core meaning of the rule of law. Actually, there is a very strong legal consensus across jurisdictions, regardless of the common law, civil law divide or the alleged East-West divide. It's not simply in EU law, actually, just across the European legal system. National and European understanding, the EU, the understanding of the Council of Europe, they all share the same core meaning, which is essentially about a number of legal principles, substantive procedural principles, which pursue all the same aim to subject the exercise of public power to constraints. So it's all about constraining the exercise of public power on the basis of a procedural and substantive requirements, which can be found almost identical in all the member states, including Poland and Hungary. What's happening in Hungary and Poland is essentially the national authorities, obviously, to give themselves a veneer of legality, and in this instance, a veneer of conceptual plausibility. They're arguing, in fact, in violation of their own national legal traditions and arrangements, that there is no such thing as the rule of law, and what they're doing actually is the real definition of the rule of law. But this is not unusual. This is typical of the autocratic playbook. I mean, Petra was mentioning scapegoating, which is a classic. So you always go after minorities to distract while you are stealing national taxpayers, for instance. That's a classic. Another one, which is a classic, while you are violating the national constitution, you're arguing, in fact, that you're not violating the national constitution, you're actually defending the supremacy of the national constitution. In a way, it would be like criminals telling the judges that while they were stealing from people, in fact, they were just restoring the natural justice order. So this is a kind of a twisted logic we have been dealing with. But from a conceptual point of view, essentially from our research, I believe, has demonstrated that there is a core consensual meaning of the rule of law. There is certainly one in EU law, and this one in EU law is legally binding. This is why I can make an educated guess, if not a prediction. This Norman grant I have mentioned at the start of my little intervention is going to be rejected. In fact, the Polish and Hungarian governments, maybe of today, they don't remember what the previous Hungarian and Polish governments committed themselves to when they joined the EU. And in fact, as part of the accession treaty, they had to comply with something which they think do not exist, but which was part of the enlargement package. So I'm afraid this is not a serious argument. And if you want to know more, please read our RECONNECT research. So that's all I'm going to say for now. Thank you.
Okay, thank you, Laurent. I think you made your point very clear that they have absolutely no point in ignoring the fact that a rule of law actually exists. Of course, an important player in this regard is the European Court of Justice. And I will address this question to Dimitri, because together with Professor Pesch, you have done ample research on the rule of law in the case law of the European Court. And the jurisprudence has, like I already said, played an important role in this ongoing rule of law crisis. Could you maybe explain whether a judicial response to rule of law backsliding is efficient, and which contributions of the court have been the most significant in this regard?
Thank you very much. In fact, it's a happy story, and it's not a happy story. It's a tragedy, in fact, that the court needs to step in so forcefully while so many other institutions and the member states are silent. So the court has not chosen. Of course, its job to protect the law is the job of the court to protect the law, but the court has not chosen to take the lead. It was simply acting in a vacuum. So the Commission, who is which is the institution responsible for making sure that the European Union functions correctly, at least vaguely as described in the treaties, is obviously the institution that had to ensure that there is no significant backsliding. Yet we have been facing what Laurent Pesch and others described as the dereliction of duties by the Commission, because we see a sharp decrease in the number of actions brought by the Commission to the Court of Justice in relation to the backsliding states, even compared to the time when they operated normally, which means that when the worst peaks, somehow the Commission is humble and silent. Well, silent is not correct, because the Commission has been active, generating some kind of foam of activities, but this foam of activities has not come down to the substance. While this foam of activities was bubbling out there, the Union was being rotten from the inside as a result of this blunt and outright visible disrespect of the law, coming from at least 2 member states, which was very meticulously described in the scholarship, and which was also visible from a number of European capitals. So 10 years ago, we saw this, well, almost 10 years ago, these letters from European ministers begging the Commission to do something. What has the Commission done? Always imitation of activities, and in our RECONNECT deliverables, and an ample number of papers from all those present in this panel, but also Barbara Grabowska-Moros and other key researchers engaged in the project, we have demonstrated beyond any doubt that it's the vacuum out there that pushed the court to the forefront. And then what the court had to do, the court had to come up with some minimally tangible solutions in order to sort out the mess that the current political situation in Europe has left the court with. And here the court again had wonderful pillars of scholarship dating back the 20, 25, 30 years that could show it the way. And here I refer to the wonderful paper by Joël and Laurent again. It's a little bit circular, but we've been working on the same thing. Especially the work of Judge Kakouris and the work of the late John Usher on how the predecessors of what is now Article 19 in the Treaty on the European Union could be interpreted in order to extend, de facto extend, probably not de jure extend, the powers of the Court of Justice to deal with outright violations in the sphere of the judiciaries of the member states. Of course, you cannot have a member state that overwhelmingly harms its judges to be operating as normal in the context where mutual trust between the member states, what Petra Barth has written a lot about, and where the vertical integration, or kind of vertical but horizontal official integration between the judiciaries of the EU and the member states is a given. So the court has extended EU's grasp of the principles and values in order to connect Article 19 in the seminal Portuguese judge's ruling with Article 2. And it has been working very well, because we saw an outpouring of cases that aim at precisely safeguarding the values of the European Union. And it has been working amazingly well in the silence of the Commission and other institutions. So if you want the details, the easiest shortcut to all what has happened is a paper that I co-authored with Laurent Pech, which is about to be published in Stockholm, which is a case book of all the decisions of the Court of Justice, which bring us closer and closer to the ideal of legal upholding of the values of Article 2. We are not yet there, but we are very well marching in the right direction. So I think I stop here.
Thank you very much for your intervention, Dimitri. I already heard you mention Article 19, and we will definitely get back to that later on. For now, I'd like to shift gears a little bit. And as we have already discussed Hungary, and we have already discussed quite literally the world with the COVID-19 situation. So I would now like to move on to Poland and address the following question to Tomek. So Tomek, you have argued in your research on the rule of law in Poland that an anti-constitutional doctrine has become firmly established in Poland. Could you please explain this doctrine and how, according to you, it might affect the chances of a definitive poll exit?
Okay. Thank you very much for this question, but let me start from the more general premise. If you really want to understand what has happened in Poland since 2015, you have to ask yourself another question. What was Europe all about from the beginning? So you have to have two groups of paradigms and then try to understand how much Poland has veered off the original paradigm of European integration. So let me start first with what we have been busy at RECONNECT and asking the question, what was Europe's promise? Or what I called in my research, what are the Europe's first principles? And there were certain few principles that informed the European integration processes from the get-go. First of all, the most important thing was to trust and believe that we Europeans have learned from the past mistakes, from the past atrocities that were created by the political power at the domestic level that was set free. So this belief in the learning process informed the decision to come together in 1951. Then we believed that it would be the power of law that would obviate the recourse to war as an instrument to settle disputes between sovereign states. And then the trust in the law translated into the belief that every political power must be a constrained political power. and that the domestic level can produce dangers for all members of the community. And finally, because I think it must be really emphasized, Europe was not about introducing this automatic trust that all together now the trust will reign supreme and everything will be in good order. No, Europe has been always about searching for this very uneasy feat about trust and distrust. Why distrust? Because we know what has happened in Europe before, and we have learned that we Europeans shared certain common constitutional essentials, and yet we know that we Europeans are also the greatest dangers for ourselves. So distrust in law, in the institutions that would constrain the political process at the domestic level was one of the founding principles of European integration. And now fast forward to 2021 and Poland, and before Poland, Hungary. Because what has happened in Poland and this rise of what I call the doctrine of the politics of resentment is in direct opposition to what Europe was supposed to be from the get-go. So first of all, the doctrine of politics of resentment is premised in the primacy of politics over law. So whatever the political majority decides goes. And this was exactly what Europe wanted to be against. It was the law that was to constrain the politics. The law was supposed to tame the politics of the day, knowing that whatever majority comes out of the democratic vote, this majority will be bound by certain constitutional essentials and basically be a constrained political majority. Then the second element of this doctrine of politics of resentment is a changing role of the constitution. One of the elements of the post-war settlement was to see the constitution as the supreme law of the land. And now the constitution in Poland is not simply seen as a reservoir of subjective rights or as a protection for the citizens against the powerful state. No, the constitution now is understood as an instrument to express the uniqueness of the ethnocultural community. It is to express the uniqueness of the state, of its history. So instead of protecting people, the constitution becomes this political manifesto for the uniqueness of the unitary people. And then finally, the rule of law and its meaning has been changed dramatically. The rule of law is now seen as an obstacle to express the will of the people. And the rule of law in the post-war settlement was to protect the citizens against the power of the state. The rule of law was to make the power, the political power, a constrained political power. And right now, the political power, doing away with the rule of law as a constraint, does whatever it wants to do, because the majoritarianism is the ultimate source of the political power. And the majoritarianism was this ultimate danger that Europe was supposed to do away in 1951, knowing all too well what unbridled majoritarianism can bring about. So make no mistake, this new political doctrine of politics of resentment and the resultant rule of law crisis, or rather value crisis, it's not about a crisis of governance. It's a crisis of certain essentials, constitutional essentials, that brought us Europeans together, and that makes us political community. If you don't respect the rule of law as the core constitutional value, then this political community has no future. And this is exactly the argument made by Polish government. There is no thing as the rule of law, because the rule of law is specific to each and every member state. And then we enter the slippery slope from now onwards. It can only get worse. So first of all, understand the rule of law crisis as the crisis of governance, and then see this politics of resentment on the rise as posing a direct threat to the promise of European integration.
Okay, thank you very much, Tomek. And luckily, Laurent has already established that the rule of law is indeed a thing, even for Poland. I can see that we have gotten some questions from the audience. Maybe I should immediately start weaving them into the conversation, because I feel like we have some very interesting questions coming up. Let me see. So maybe the first one to Professor Pesch and Professor Kochenov. So the 2020 Rule of Law review cycle was introduced by the Commission, but it has faced a lot of criticism. How do you consider it could be improved with regard to the prevention of rule of law backsliding? And what measures could be implemented by the Commission that might be more effective to prevent the future backslash within the EU?
That's a very good, difficult question. So yes, a number of us actually have written before the first edition of the annual rule of law mechanism or report, as it's called now, to warn the Commission about what it should not do. We have kept saying that certainly we don't need more reports. You don't need dialogue-based processes. Autocrats, would-be autocrats, couldn't care less about dialogue-based processes or reports. They're just going to use the time being wasted to change the facts on the ground. Sadly, most of the warnings, most of the things we told the Commission not to do, the Commission happened to have done them. Which means that the first edition and most likely the second edition of the rule of law report of the Commission they suffer from major shortcomings. So in the short term, actually, the impact of the rule of law report, I think, is certainly almost non-existent as far as I'm concerned. What we need in the short term is legal actions plus financial sanctions. What we need is enforcement. We don't need more dialogue. We don't need more reports. That being said, there is room for improvement, and there's potential for actually a meaningful impact of the annual rule of law report if it's done properly. We have made a number of concrete recommendations, and one of the recommendations is to actually include deadlines and first, the Commission must identify, when it does identify clear violations of EU law, it must say so explicitly in the reports, then make concrete recommendations and impose deadlines. That would make the report already a bit more interesting and more effective potentially. I understand why essentially the Commission went for a soft version of Rule of Law first edition and most likely second edition, but currently, as I said, my bottom line, and perhaps Dimitri can say whether he agrees or not, but I would say what we need urgently is actions and sanctions, because we need to make sure the situation doesn't get worse. I'm not saying that actions and sanctions are going to improve things, but we need to contain rule of law backsliding. It's now essentially has moved from rule of law backsliding in Poland and Hungary to complete a rule of law breakdown in Poland, for instance, where the sham bodies consisting of unlawfully appointed individuals no longer recognize essentially the judgments of the Court of Justice on rule of law matters. And now this authoritarian route or gangrene is reaching the ECHR system, with the unlawfully composed Constitutional Tribunal of Poland recently finding that he has the authority to find the judgment of the European Court of Human Rights non-existent. So the situation is worse than ever. This is not going to be changed by any report, especially the way they are phrased and drafted and structured. So sorry for not being more uplifting about the rule of law report. I'm sure he was done with good intentions, but he hasn't changed much on the ground.
Okay, Dimitri, then maybe, do you feel differently about this, or do you want to add something?
I agree and disagree a little bit, because when some random people who are dressed up in carnival mantles parade themselves as judges, it doesn't matter at all whether they disagree with what the European Court of Justice says or not, ideally, because they are not there to agree or disagree. They're simply in the wrong place. They are the imposters, they are the usurpers, they should not be on the bench. And this is how bad it got. So the commission with its rule of law reports is basically a firefighter who, instead of using the brunt sport, instead of extinguishing the fire, sends someone to the library to fetch a book about the nature of how fire is being made, etc. Simply observing the terrible consequences of being sadly so slow. And there is it's difficult to imagine an excuse for that, because the Commission has all the tools, as our projects have also demonstrated, in order to act, and it chose not to. So it's really a sad story, and I entirely agree with Professor Pesch.
Okay, thank you very much. I see another question came in for Professor Bart. And this ties in with a question that I had for you myself on the IS case. So maybe I will first read out my question and then tie in the question that was asked by the audience, so that you can maybe answer both at once. Does that sound okay to you? Okay. To give some context, we have recently seen Advocate General Pikamai's opinion on the IS case, which is a case that originated from an Hungarian criminal proceeding in which the national judge referred three preliminary questions, three questions for preliminary reference to the CGEU. The Hungarian Supreme Court later held the reference to be unlawful in the interest of the law, and disciplinary proceedings were started against this judge. Could you explain how this case relates to the inaction of the EU Commission to deal with rule of law infringements, and what effect this case might have on the use of the preliminary reference procedure for other national judges in the future? And then a member of the audience asked, why are there no preliminary requests from Hungarian judges concerning the rule of law? Is the Hungarian judicial system already completely overtaken by political control?
This is a very relevant question, so thank you both for asking this. And what I will say very much rhymes with what Laurent and Dimitri had to say on the matter and on EU inaction. So I think we can take it for granted, and this is also what our research has proven, that we have member states that are not democracies anymore and that couldn't join the EU were they to apply today. And we could also agree on the fact that rule of law backsliding in any member state is an EU matter. As it has already been said, we have proven in a series of papers, RECONNECT papers, that the EU possesses the tools that could put a halt to rule of law backsliding if these tools were used forcefully and in a coordinated manner. Now, the tools that I could list as enforcement tools, they of course do not cover monitoring tools or benchmarking tools. So I really have in mind hardcore enforcement tools such as Article 7.2.3, the sanctioning prong of Article 7, infringement procedures, or the conditionality mechanism, or the common provisions, which was a kind of a conditionality mechanism for almost a decade now. Now, preliminary references are not the schoolbook example of the enforcement toolbox. Preliminary references are there because it is not the sole task of the Court of Justice to enforce and apply EU law, but this is a joint responsibility of national domestic courts and the Court of Justice. So whenever it's unclear how to interpret a piece of EU law, the ultimate interpreter is the Court of Justice, and therefore domestic courts have the right and sometimes even the obligation to turn to the Court of Justice for clarification of a piece of EU law. So whenever this right, and as I said, sometimes obligation of domestic judges is jeopardized in the domestic setting, the Court of Justice immediately reacts forcefully to such attempts. And this is exactly what happened in the case that you are mentioning, the IS case, which did have a cross-border element in the sense that the suspect was not a Hungarian national. and the referring judge had some doubts as to the quality of the translation, but more importantly, he also asked a couple of questions about the independence of the judiciary. So this is a rather unusual case, because the other cases we know, which are similar, in those cases, another court from a democratic country had some doubts as to the independence of other member states and member states courts. Now, in this case, the Hungarian judge himself asks the Court of Justice whether he is independent or his court was independent. Now, because of this reference, the Prosecutor General started a procedure against the reference and against the judge, and the Supreme Court agreed on all counts with the Prosecutor General and declared the reference illegal or unlawful. Now, this is a very specific Hungarian legal instrument because this only has a declaratory effect. Nevertheless, it's very important because lower courts now, especially now because the law was amended, are obliged to follow what the Supreme Court is saying. So even though it doesn't affect the actual reference, it will have a chilling effect for further such references. So this might be one of the reasons why you cannot see more of that. Now, the original submission was then amended by Judge Vasvári, to call him by his name, and he asked, what to do with this declaration of illegality, and also disciplinary proceeding has been started against him just because his reference was declared to be illegal. And this disciplinary proceeding has been dropped in the meantime, mainly due to public pressure and also international pressure. But that's the only reason. So a much lower profile case would still fly, and a judge would have to undergo a disciplinary proceeding in similar shoes. So far, we only have the Advocate General's opinion, and the Advocate General recommends the court to admit these questions, especially the ones referring to the declaration of illegality and also to the disciplinary proceeding. And if the court followed the Advocate General's opinion, which I very much hope it will, then it could rely on its previous case law regarding Polish judges, where it held that the mere prospect of a disciplinary proceeding, whether it was dropped or not, is likely to undermine the effective exercise of Article 267 of the Treaty of the European Union. So in my view, this case should have never reached the Court of Justice. Had the institutions did their job, and especially if the Commission, as guardian of the treaties, started infringement procedures pointing to the systemic problems, if an Article 7 procedure was dissuasive and effective, and there were legal consequences attached to judicial capture, this case, or even conditionality, for the distribution of funds, is absolutely crucial to have an independent judiciary, so that anyone who, for example, loses a case in public procurement can be sure that he can turn to an independent judiciary and can potentially win a case even against the state. Now, if these instruments are not invoked, then the judges, as Judge Vasvári, will be compelled to turn to the Court of Justice. So I think this case is absolutely crucial in many respects, but mainly because this is a chronicle of EU inaction and silencing and silence, normalizing harassment of judges and violating their independence. So thank you for the questions once again.
Thank you very much, Petra. I'm going through the questions of the audience, and now that we just talked about the Hungarian judges, maybe we can talk about the Polish judges as well. So I see a member of our audience asked the following question: can the destruction of Poland's courts be stopped by an EU reaction led by the case law of the European Court of Justice? So maybe Tomek can first have a go at this, and then if anyone else wants to chime in, then we can start the discussion.
Yes, thank you for this question. I believe that in order to understand the gravity of the problem and to try to map out possible solutions, it is really crucial to understand that there are limits to what the courtroom can produce. So the rule of law enforcement within the EU is a joint enterprise. There is a role for the political and there is a role for the judicial. Yes, Article 19 of the treaty, which says that the Court of Justice ensures the observance of the law in the application and interpretation of the treaties, it's a powerful reservoir of implied powers for the court. Some claim that it is really a judicial power unbound. I disagree with that. But again, Article 19 has clear limits because the judicial method works according to certain principles. So the judges can go very far interpreting the treaties, developing the law on the basis of the treaties, but they cannot take the place of the responsibilities that are vested by the system within the political branch of the government. So the cases must be brought. The cases must be framed in a correct manner so as to make sure that the judges know what the problem exactly is. So that would be my answer. And then again, we really have to remember that the law can only do as much. We really have to create this missing feeling of and asking the question: if the Commission or any other institution enforces the rule of law, the basic question that must be asked today over and over again is this: enforcing the rule of law in the name of whom? Not in the name of some faceless institutions, but in the name of the citizens. And unfortunately, Europe is falling miserably on the front of building the civic narrative, telling the people that the Polish rule of law matters to you, Dutch, French people, just as much as it does to Polish people. So this is our rule of law enforced in the name of the people. And we can have many future conferences on what should be done. We can have many imaginative proposals for the institutions to step in. But as long as we don't understand why Europe is doing what we wanted to do, then we will be falling miserably on this enforcement front. In the name of whom? In the name of the European citizens.
Thank you very much, Tomek. Yeah, Laura, please come in.
Very briefly, just to complement Tomek's answer, and very briefly, actually, the Court of Justice has done the job. There's nothing really left for the court to be done. All the legal principles are there. What you need, however, is independent Polish judges left to apply the case law of the Court of Justice. Sadly, any Polish judge, and they're so brave, I'm in admiration of so many of them, but anyone who dares actually applying ECJ judgment, then you can find yourself very quickly under multiple disciplinary proceedings, and in some cases, criminal charges completely bogus, brought by captured prosecutor's office, and you find yourself before kangaroo courts controlled by the ruling party. This is why, in fact, the issue is not the case law of the Court of Justice. The Court of Justice has done the job. The issue is, as Tomek was saying, the political institutions, especially at EU level, but I would argue also at the level of the Council of Europe, not fulfilling their duties. They were set up post-World War II as counter-majoritarian institutions with the view of defending exactly the rule of law, democracy, and respect for human rights in the face of authoritarian regimes which might just be resurgent. So they're failing at the job. In the EU, the Parliament is actually doing very good work, but the two main institutions with the most powers, which are failing to fulfill their duties under the treaties, are the Commission and the Council. The Commission could have achieved a lot more if, instead of wasting 2 years on dialogue-based processes, they would have, for instance, brought an action against the unlawfully composed Constitutional Tribunal. What Petra was saying about LGBT people in Hungary, actually, it all brings back the same main issue, which is once you have captured or undermined the national rule of law safeguards, then you can destroy the rest of the system under a veneer of legality. And it was bound to, at some point, directly affect people's human rights. Think about abortion rights, for instance, in Poland. I mean, it's not even, so there were obviously, you may remember what happened a few months ago in Poland, but essentially the unlawful Constitutional Tribunal was used to essentially deprive Polish women of their pre-existing rights on the basis of a joke of a judgment issued by a kangaroo chamber of the Constitutional Tribunal. So yes, so sorry, I said short, but not short, but it was a great question asked by Professor Barrett of UCD, if I recognize the name. So the case law is there. What we need is the Commission to make use of it as a guardian of the treaty. We cannot ask Polish judges to sacrifice their professional and family life just to apply EU law. This is not the way we designed the system to be. Thank you.
Thank you. Yeah, I shortly wanted to ask Dimitri to come in anyway. So Dimitri, go ahead.
I would just like to bring the European Court of Human Rights into the picture, and it's particularly timely, probably following the spectacular appearance of the president. And the European Court of Human Rights shows us a different way of tackling the same issue compared with what the Court of Justice has been doing so far via Article 19. It's not independence; it's the lawfulness of composition. And here, what is striking is that it basically took the Court of Human Rights several paragraphs and several floor to prove that the kangaroo court, which calls itself the Constitutional Tribunal, mistakenly in the Republic of Poland, thereby spitting at the idea of the law, actually is not a court. And this is something that the Commission had to do years ago by bringing a direct action against Poland on the basis of Article 19, which the Commission thought would not give it any standing and would not give Article 2 any real life. So this timidness and the failure to act so the current reality is something that we could thank the Commission to in large part, regrettably, but the Court of Human Rights is there to help us where the Commission again has failed.
Okay, thank you very much. Now, steering us away from the case law a little bit, we have an interesting question from our colleague Peter. And I think it's addressed to all panelists, but I will start with Joël. So in the hypothetical case that rule of law in the EU would be restored or safeguarded, would this reconnect EU with its citizens? So how many citizens actually dislike the EU because our rule of law is flawed? And Joël, feel free to add in information on COVID and whether this has any effect on this.
Yeah, I spotted Peter's question. I was excited for everyone else's answers on this. But let me be simple. Let me be very, very simple and straightforward when it comes to values, which is that in terms of the rule of law, we only notice it when it's gone. We only notice the lack of democracy when it's no longer there for us. We only notice that we don't have rights when we don't have rights. So if I asked an ordinary person on the street, in fact, if I asked my mother, even while I was doing my PhD many years ago, what is the rule of law? I doubt that she would be able to give me a clear and coherent answer. But if instead I phrased it as, are you worried when you go to court, you might not have an independent judge, that you might have someone with political connections that might mean that they could rule against you? She would say that's wrong. If I asked her, are you worried that your government will trample over your right to access public services, that they will trample over your right to have your daughter with you, that you will be no longer able to vote? Is that a problem for you? I have no doubt that she would have incredibly strong reactions. So anytime we talk about the idea of the rule of law, of democracy, of fundamental rights within the context of the EU, we are talking about our common values, our common foundational values. We are an EU not only of 27 different countries, and I cry internally that even though I'm an Irish citizen, I'm now outside of the EU as I sit in the UK. But these are the values that join the EU together. We have so many cultures, so many conflicting ideas as to what the future means for us. But the common values of democracy, of rule of law, of rights are foundational. They are what connect us. And even within the context of my COVID research, and I'm going to point to the two fundamental takeaways, not only within the research of recovery within the European Union post-pandemic, but also, again, I look globally. I'm going to say that there are two. First, public trust, and second, solidarity. it's been shown that the single most important factor in terms of response to the pandemic, not only in terms of mortality rates, in terms of public health, but also in terms of the economy and the political system, is public trust. And the most foundational elements of public trust are rule of law, human rights, and democracy. So when I look globally and I see the states that are most clearly cohering with those principles through democratic innovation, through clarity in terms of their policies, through transparency in the decisions that they're making in response to the pandemic, they clearly cohere, they clearly correspond not only with the highest levels of public trust in government, but also with the best recovery, the most resilient legal systems. Public trust is essential. Second, and I speak so much to the EU on this, is solidarity. When we look to resilience, when we look to recovery, when we look to how we need to rebuild better into future, not only in preparation for future emergencies, but also just in response to the ordinary life that we live, it must be based on solidarity. Now, recovery from the pandemic means solidarity, not only in terms of vaccines and public health provisions and resources, but also solidarity between member states in how we recover together. So in response to Peter's wonderful question, and can I say I am so disappointed I am not currently in Leuven and well, sharing Trappist beer with all of my dear colleagues, but very, very simply, the rule of law, fundamental rights, and democracy are the foundations of public trust. They're also the foundations of our values. They're the things that connect us. They're the things that make us most resilient to emergencies and best capable of responding into the future.
Thank you very much, Joël, for your very clear answer. Does anyone else on the panel want to come in on this question? Not really. Okay, then I will immediately go over to another question on actually trying to restore the rule of law or contain at least rule of law backsliding. And that was also quite recent. We finally had the long-awaited rule of law conditionality regulation that was adopted in December of 2020. Laurent, you have been very vocal about how this instrument, and more specifically the European Council conclusion on the instrument, are not in line with the rule of law itself. Could you explain how so? And do you see any solutions on how this instrument might still contribute to enforcing the rule of law?
Yes, a good question. Again, all very good questions. So thank you very much. So just long story short, so in last December, the European Council decided to issue conclusions regarding what we call the rule of law conditionality regulation of the EU, adopted about just at the same time. The European Council decided to essentially de facto suspend the application of the regulation until after a judgment of the Court of Justice, and to force the Commission to adopt the guidelines, which must also be finalized after the judgment of the Court of Justice. Now, these two conditions, I didn't say they violate the rule of law. I said, I wrote that they violate EU primary law. First of all, to begin with, the European Council has no business telling the Commission what to do as a guardian of the treaties. And the second, straightforward violation of the EU treaties. The European Council has no jurisdiction, no authority whatsoever, or no one, in fact, has any authority to suspend the application of EU legislation, so regulations or directives. That's explicitly written down in the treaties, so they could not have missed it. So these two conditions, essentially, they are straightforward violations of the EU treaties. Sadly, for a number of technical reasons, which I'm not going to mention, the European Parliament decided against suing the European Council on the argument that formally, which is right, the formal argument is European Council conclusions are not legally binding. But why is this wrong? Because they have produced de facto legally binding effects, or are treated as such de facto binding by the Commission. So a straightforward violation of the treaties. What might be interesting in this context is to see what the European Parliament is going to do. The Parliament has threatened the Commission with a failure to action before the Court of Justice if the Commission does not apply the conditionality regulation within the next 2 months, if I remember well. So we might see the European Parliament suing the Commission because the Commission has decided, in breach of the treaties, to listen to the European Council for political reasons. So it was very disappointing. It's just giving more time to those violating the rule of law, not only to keep violating the rule of law, but also to keep stealing EU money. So well done to the European Council, well done to the German presidency. Thank you.
Yes, Dimitri, please come in.
What Laurent described is not the only problematic issue at the EU level when we speak about the rule of law. So I don't want to be a party pooper, but I think especially in the context of what's going on in Poland, the European Court of Justice has not been perfect and neat and absolutely clean in dealing with its own situation vis-a-vis strong pressure from the member states. Most notably, the European Court of Justice refused to review under pressure from the member states, clearly, the legality of all the member states' decisions regarding the legality of its own composition. So what happened after Brexit, the member states decided to kick out one of the advocates general who had a British nationality and was appointed by the UK, notwithstanding the fact that the treaties actually do not connect the nationality of the Advocate General with holding, the fact of holding the office. They simply decided to do it by blunt force, not via creating a vacancy, but via simply appointing someone else in the place of a sitting Advocate General. And the Court of Justice decided to play along in violation of all the principles that it has just formulated in the context of the fight for the independence of the Polish judges. So now, in theory, we can say that since the first vice president of the court, the vice president, sorry, of the Court of Justice has clarified that the Court of Justice does not have any say against what the member states think about its composition, even if the member states bluntly and directly violate the law, the Court of Justice doesn't enjoy formal independence in the eyes of the law. So these are the questions that we should keep in mind. It might be a one-off, it might be something exceptional, but still the Court of Justice does not necessarily meet its own criteria of an independent tribunal established by law.
Thank you very much, Dimitri. Let me look at the other questions that have come in by the audience. Another slightly hypothetical question from another colleague of ours, also addressed to the entire panel, but maybe Tomek can go first. How about establishing an EU Constitutional Council, like Joseph Weiler proposed a long time ago, which would involve both members of the European Court of Justice and national constitutional courts? Might this not be more effective in adjudicating rule of law violations?
Well, I'm having a serious problem with that proposition because it reminds me of an old saying that if the EU has a problem, then it invents a new institution. Look, the challenge before all of us is to maximize what is out there, what is available, rather than look out for some comfortable exits by creating new institutions. Second point is this. How do you create a constitutional court for Europe if you have constitutional courts within the EU that are clearly compromised, that are clearly rubber stamping whatever is decided by the political majority? And I think it is very, very important, and I'm following up on Laurent's extremely strong words, that words we use to describe the reality do matter. Polish Constitutional Court is not a court. The EU should accept this and deal with the fact that the judicial review in Poland has been compromised. The Committee of Constitutional Courts within the EU can only work as long as there is a good faith among those who belong to the Committee of Constitutional Courts. And finally, today, we are entering a completely new stage in the constitutional disagreement in Europe. Because constitutional courts might disagree with the ECJ on that point or another, But with the Polish Constitutional Court, for the first time in the history of European integration, we not only have a disagreement, but we have a clash of ideologies. Polish Constitutional Court sends the message, listen, there is no consensus, there is no willingness on the part of Polish Constitutional Court to play the game of accommodation, of judicial dialogue, etc. All those principles are rejected up front. And the challenge before the elites, the European elites, is to recognize the reality as it is, rather than to look for some exit strategies that long-term will simply not work. They will only worsen the situation. So it is not only what you say that matters, but what you do. And I think that's the most important takeaway from the value crisis within the EU. Do something. Instead of fiddling, understand that the Rome has been burned. And I still have the impression, like, every time I talk to the European politicians, they ask me questions about how to better redecorate the interior of the apartment. And I tell them, listen, how can you ask the question about the decor when the walls are missing? So we need to switch the narrative. We are dealing with the crisis of constitutional foundations rather than with some technicalities that might be remedied on an ad hoc basis. And that's the biggest challenge. Let the leaders know what they are dealing with. And I think right now we are failing miserably on this front.
Yes, Laurent, please.
Just to add that this idea, I think, has just been endorsed today by Orban, Kaczynski, and Le Pen, this idea of a constitutional court composed to overwatch the Court of Justice. For me, obviously, the authors of this idea are great experts, but to me, it's a bad idea to answer a non-existing problem, which would just end up actually undermining the only effective institution when it comes to the rule of law, which is why, unsurprisingly, he has been endorsed by Orban and the new breed of autocrats we are now facing in the EU. So I would have to agree with Tomek completely. That's it from me on this question.
Okay. Thank you very much, Laurent. I immediately want to bounce another question of you. Since Tomek already touched upon, and we touched upon it a couple of times, that we should maximize what is available and that the Commission should take more action. Now, in June, the Commission sent a letter of formal notice to Germany for breaching the principle of primacy of EU law. Could you maybe summarize and explain why this particular infringement procedure is important and whether this actually makes you hopeful for more action of the Commission in the future?
So I'm supposed to answer this very good question again, difficult one.
Yeah, sorry.
Unless someone else wants to step in, but essentially, yes. So this is the so famous or infamous, from my point of view, PSPP ruling of the German Federal Constitutional Court. So long story short, the German Federal Constitutional Court violated straightforwardly the EU treaties when it decided to find ultra vires both a decision of the European Central Bank and a judgment of the European Court of Justice. It was, for me, just to put it shortly and strongly, an irresponsible judgment based on a first-year law mistaking understanding of EU law. So it's not simply irresponsible just in the greater overall scheme of things. It's actually based on a complete flaw understanding of EU law. They should have known better. They should have done their duty under the EU treaties, which is to refer back the matter to the Court of Justice if they were not happy with the first judgment of the Court of Justice. This has been done before. Not to say that the Court of Justice is always right, but the German Federal Constitutional Court is under a clear duty. He has no jurisdiction to find under EU law the judgment of the Court of Justice, especially in an area of exclusive competence of the EU. You could argue actually that the German Constitutional Court has misinterpreted here the European law obligations enshrined in the German Constitution, as has been made, the argument has been made by several German law professors. So I would say this is certainly irresponsible. I mean, and unsurprisingly, This has been used or misused by the kangaroo courts, the kangaroo constitutional courts of Poland, Hungary. And now also, perhaps unexpectedly, the Constitutional Court of Romania is trying to undermine its reputation very dramatically and very quickly. Recently, the Romanian Constitutional Court has just disregarded completely not only its obligation under EU treaties, but also a judgment of the Court of Justice, again, using or misusing the concept of constitutional identity with also the German Constitutional Court ruling in the background. So essentially, long story short, the Commission did right. The Commission should have done that the month following the ruling instead of waiting 12 months or so. I hope this is just a prelude to the Commission actually suing the Constitutional Court of Hungary, the Kangaroo Constitutional Tribunal of Poland, and also the Constitutional Court of Romania. In these three instances, we have straightforward violations of the EU treaties, and this is done with the view of undermining judicial independence requirements. This is what happens when you don't deal with authoritarian gangrene, then it does spread. So this is why we've been quite critical of the guardian of the treaty, even though we can be even more critical of the European Council/national governments. If you don't deal with the problem, your problem is going to be worse. And this is where we are. We could have dealt effectively with the situation in Hungary in 2012-13. There was a great report, a great resolution by the European Parliament. The rapporteur was Tavares from Portugal. Everything which needed to be said was said in the resolution, but the Commission and the Council and the European Council didn't listen. So very frustrating, because everything which is happening has been predicted by experts. In the case of Poland, 12 months before the next step in undermining the rule of law was predicted by experts on this panel. And yet nothing was done. It's like a deer caught in the headlights every single time, even though every single time we know exactly what's going to be the next step. So a bit of frustration, but the short answer to the question, the Commission did right, even though I know some people might disagree.
Thank you very much, Laurent. So that is one opinion. Then Tomek, maybe you can come in first.
Just a very short comment I think for the benefit of the audience. Your first question dealt with Polexit, and now we are kind of coming together, because with now pending application before the Polish Constitutional Court by the Prime Minister claiming that some of the treaty provisions are unconstitutional, you have to understand how far we have come since 2015 if you look at what kind of irregularities are alleged by the Prime Minister. First, Polish Prime Minister claims that Article 1 of the Treaty on the European Union that provides for an ever closer union among the peoples of Europe is unconstitutional. So the very foundation of the European integration is right now before the Polish Constitutional Court. Second, Article 4 of the Treaty on the sincere, loyal cooperation, again, the Prime Minister claims that the obligation to cooperate sincerely among the member states is unconstitutional. And finally, for Prime Minister, Article 19 of the treaties that has been there forever, since 1951, defining the function of the court is unconstitutional as well. So if you put it together, then Polexit is not some nice conjecture. This is a reality that is happening right now. Polexit has started with this very application. But again, we are simply at a stage where non-actions in the past has enabled all this and has encouraged and emboldened the Polish authoritarians. And this is what it is. We have what we have, partly as a result of the inaction or the action that should have been taken by the Commission long time ago. And one last point, which should be really remembered. There's only one case in post 2015 when the Polish government stepped back. When was that? When the Court of Justice has threatened Poland with financial sanctions following its interim order in the Białowieża case. And it was December 2017. What has happened since? Nothing. So the only way to deal with the Polish autocrats is to reach for the purse and to punish them with some sanctions, financial sanctions that would be felt across the board. Kaczynski understands the money talk, and there is nothing coming here from the European Union, unfortunately.
Thank you very much, Tomek. Dimitri, do you also still want to comment on this?
Very quickly, I just wanted to play a devil's advocate on 2 points. First, kangaroos are such remarkable animals, and we only use them negatively somehow. So I would probably find a better epithet to describe the Polish Constitutional Tribunal. And the second, I think there is certain danger in putting the Bundesverfassungsgericht on the same in the same box with the fake courts. So I think it's very difficult to make an argument that you need to treat the Polish and Hungarian courts similarly to the German court. And the German Constitutional Court is an established leader in its field, whatever we think about that particular decision. And in this sense, I think, and I might be too conservative, but I think there is bigger value in honest dialogue between the courts than the blunt proclamations of supremacy, which cannot work. Because simply a reference to the treaties is not enough, as we've seen in Poland, as we've seen in Hungary, and it's not enough there, just as it's not enough in Germany. You need to convince your interlocutors, who are brother judges at the national level, that you are right. And in this sense, this action by the Commission is an interference with how the intercourt dialogue proceeds. And I give you one example of why I think so. The same action could have been started when Solange cases were pouring in, and we know that Socratic contestation can lead to the improvement of the constitutional system in the long run. This was exactly the outcome of previous skepticism of the Corte Costituzionale in Italy and also of the Bundesverfassungsgericht in Germany. Now it might be not the same case, but still we need to keep this in the back of our heads. German courts are not the same as kangaroo courts, and poor kangaroos should be left out of the equation.
Okay, thank you very much, Dimitri. I see we are almost at the end, so I'd like to come full circle on this panel and end with 2 questions, one to Petra and one to Joël, but please be very brief in your answers. So to Petra, another question from Peter. Has the EU's strong verbal response to Hungary's recent anti-LGBTQI+ law increased his chances of being re-elected next year? And his, I assume, is Orban.
I wish Peter was on this panel, because I think this question is much better suited for him. I'm just getting lost in the important legal details, and I really don't know what effect such a measure would have. I think it's always a matter of balancing whether more harm is done by EU interference or not. And I know these arguments, some of these arguments, they say, yeah, it's up to the Hungarian people to change their government if they wish, but I'm not very convinced about this argument, because how can you persuasively argue for that when there is no media freedom, no media pluralism, and there is no election law that would ensure a fair election? And then you could also say, yeah, it's better to have the Hungarians in than to have them out. I call this the good old Council of Europe argument, because the Council of Europe, a human rights organization, also harbors member states that have a very poor human rights record. And here, for me, the question is how far you can go with tolerating the intolerance without them destroying the whole system from within. But this really leads to the question of legal philosophy or Ajaya Berlin, and I don't want to enter this field now because we don't have the time for that. I do think, however, that the EU is falling apart. also in terms of values and also in terms of first principles, as Tomek so eloquently summarized. So also EU law as such, the principle of supremacy, the principle of direct effect, the principle of mutual recognition, mutual trust will not work if the European Union also remains silent. And just a final note, I am not an expert on this, but when we acceded to the European Union, there was a large number of individuals voting in favor of EU accession. And I don't think that they also went for the economic benefits, but there was a strong hope on the side of the Hungarian population that democracy and transition to a society based on the rule of law, respecting fundamental rights, will be a one-way road and no U-turn would be taken. So you cannot just say this is what the Hungarians want, because this is a very divided society. And you also have to understand that those who vote the current government into government, they are numerically in the minority, even in the, if you just take a simple minority, they are under 50%. So it would correspond to the interest of the European Union on the one hand to interfere, but also to Hungarian people, I believe. Thank you.
Okay, thank you very much, Petra. And then the last closing remark from Joël. Joël, of course, the pandemic comes with exit strategies. Looking forward, do you think that these strategies will actually contribute to upholding the rule of law, or do you think that it's a lost cause?
I think as essentially an optimistic academic, I don't believe in lost causes. But to be candid, this is a key point. How we exit emergency is determinative of the future. If we live in a constant state of emergency, we see the negative sides of that. We inevitably see the worst of it. So just as I'm aware that there is so little time left, I will actually answer by commending everyone to be reading the research of RECONNECT. It is one of the great privileges of my life that I can speak so openly and so critically about governments worldwide, not only in terms of the lack of exit strategies that we see in Europe, but also in terms of rule of law and democracy. It's such a privilege being on this panel and again, listening to my colleagues saying exactly the same thing. But I would say in the context, and I hope this is the one thing that would join us, which is even as we are so critical because we are so desperately concerned as to the state of democracy and the rule of law in Europe, our research goes to how to improve it, but how to make it better, how to stop rule of law backsliding, how to start front sliding in the rule of law. I'm going to look to Laurent in improving my language on this. So again, as my last point, not only to thank my wonderful colleagues and again, lament that we cannot be going to the local bar in Leuven, but the research that we do is answering all of the questions that have been asked and more. We look how to make things better. We don't just look to how things are so bad already. So for anyone out there listening, everything that we've said is available online. All our research is open access. All our work is open, even if it's critical.
Thank you very much, Joël, for your last remark. And thanks to all of you for being such wonderful panelists and answering these questions so marvelously. So I really hoped for the audience that you enjoyed our panel, and I will now hand over to Nadja for the closing remarks on our conference. Nadja, we can't hear you.
Thank you very much indeed, Maaike, for so eloquently moderating the discussion of such a strong panel of RECONNECT researchers. Our gratitude to all rule of law warriors for your interventions. Speaking on behalf of the KU Leuven RECONNECT team, and as Maaike very well concluded, we are at the end of our conference, and there's really not much more to say than to express our great appreciation to all speakers and the audience for your mutual engagement throughout today's conference. Together today, we have discussed both interlinked limbs of the RECONNECT project, examining the fundamental founding values of democracy, and our first panel particularly interacted on the contentious nature of the Conference on the Future of Europe, as well as the rule of law, where we just heard strong pleas for action regarding backsliding state. We have had the opportunity to frankly engage with two keynote speakers on existing and new tools to uphold values that are deemed core by the European citizenry. And one thing became clear: in the final year of our project, we have a colossal task ahead of finding a new narrative to bring these values back to the core and to the fore of the European future. So do stay engaged with us as we will bring forth the project's policy recommendations and potential treaty changes in this regard at our project's closing next year in spring. So stay tuned on our website, on social media, and we hope to welcome you back soon. Have a very nice weekend, everyone. Goodbye.